So let's move on to the fifth lawful basis of processing personal information as defined by GDPR. It's public tasks. If you need to perform or process personal information with respect to a public task, it's a legal basis. You can do that without the consent. Welcome to my YouTube channel where you have been getting daily new content on data privacy. And as I mentioned, we are going to talk about the public task processing under GDPR today. So what categories or what are these public tasks? Any reasonable task which a public authority has to conduct for the citizens is a public task, and GDPR says that in that case you really don't need to go on for a consent. You can process the personal information in public interest through the official authorities or public authorities in the country. These could be legal duties, for example, providing infrastructure development, statutory functions, regulatory functions like tax collection and all. They all come under public interest or public duties. Education, healthcare, public safety. So any actions or tasks done under these categories can be processed, and for that you don't need a consent from the respective data subjects. Let's look at a few use cases for the same. For example, when you talk of schools and educational institutes, what are those kind of tasks? If they have to do something for manage the exams of the data subjects, manage the attendance of the data subjects, and especially safety of the data subjects. It could be an event organized for the school within the premises or outside the premises, and for the safety of the data subjects they need to get some activities done so they can process the personal information. Healthcare, patient care is always a very critical thing, and for patient care, if you need to process personal information, monitor diseases in an area, conduct public health programs, they are also public tasks. Law enforcement agencies needed for investigations or public safety, it's again a GDPR based public task. And if the authorities need for urban planning, they want to do some infrastructure development, they want to launch some housing schemes, transport, then these are all again considered as a public task, and as per GDPR you can process the personal information under these categories without the consent of the data subjects. To stay compliant under the public task matter of GDPR, you need to have a legal foundation of why you have processed the data. What was the need of processing the data? There has to be a transparency with data subjects. You should inform them, or you should put it in your public notice or privacy notice that you can, in public interest or in public task, process their personal information. You are again expected to process minimum possible information, no excess processing of information, like you need to provide only the photograph of your students to the emergency agency who is helping you to conduct the program, or a public health program is being conducted and you need to circulate the personal information of the workers, public health workers working with you, or the safety of the people attending your program. Then you do only the kind of information that you need to circulate, not that the entire information that you as a healthcare agency have with you. And you have to take care and respect the rights allocated by GDPR for the data subjects. You cannot violate data subjects' rights to conduct your public tasks. So that's about the fifth lawful basis of GDPR for data processing, which is public tasks. I hope you like the content of my video. Press the like and bell icon. Share my videos with your friends to help them increase the knowledge about data privacy. Share your feedback in the comment section and subscribe to my YouTube channel if you have not already done that. Thank you.